Good
evening to all of you. Today's lecture is on the Contracts Act and purely on the introduction of the Contracts Act. Please bear in mind that the Contracts Act is a very verbose enactment and you have to follow it very, very carefully. And, uh, and it's a 60 days period and interaction we'll have it after the Contracts Act is completed. After the completion of the subject, we'll have the interaction so that you'll have a first time.
We'll have an introduction separately.
But today there will be no interaction, please. There's an announcement which I have to make. As far as the Contracts Act is concerned, the introduction to the Contracts Act is, it is supposed to be the great grandmother of the entire mercantile world. Without Contracts Act, there is no commercial law. So as far as the Contracts Act is concerned, it has given birth to even grandchildren also. The Contracts Act was passed in the year 1872. I think you know also 1872 is a very important year where the old Indian Evidence Act also was passed in 1872. Of course, the first enactment which was passed in this country was the Indian Penal Code, Old Indian Penal Code of 1860. 1872 saw a lot of change as far as the commercial world is concerned, and for the first time, the entire commercial law was codified in the form of the Indian Contracts Act of 1872. As far as the applicability of the Contracts Act is concerned, it applies to the entire country except the state of Jammu and Kashmir. But now the recent development is after the repeal of Article 370 of the Constitution, the Contracts Act also applies to Jammu and Kashmir. Here, the Contracts Act is divided into two parts. One is called the general contracts, and another is called the specific contracts. General contracts are called the general principles of contract from section 1 to section 75. Specific contracts are from section 120 to 237. Amongst these sections, actually the Contracts Act originally contained 239 sections. Out of the 239 sections, nearly about 60 to 70 sections have been repealed. So today, we have the Contracts Act in an emasculated way to say that it consists of nearly only 160 sections. First and foremost is the Contracts Act is divided into two parts, I told you. General principles of contract, that is from section 1 to section 75. And then after that, you have got the specific contracts, which are from section 120 to 239. In the middle, some of the sections have been deleted or repealed. First and foremost, you must understand is that the fundamentals of the Indian Contract Act. First of all, the ambit or the purport of the Indian Contract Act is the definitions part of it is very, very important. First and foremost is, I told you also in Telugu they say Onamalu or the alphabets of the law. It is contained in section 2, which is called the interpretation clause, which consists of all the definitions which will come later as far as the topic is concerned. The first term that is defined is what do you mean by a contracting party? A contracting party is one who enters into a deal with the opposite side and is called the contracting party. The first term that is defined under the Indian Contract Act is called offer. Second, offer it means where a particular person makes a proposal to the opposite side regarding a particular thing, then is said to have made an offer. Where a person makes a proposal to the opposite side, stating certain things in order to enter into an agreement, is said to have made an offer. The second thing which is defined is acceptance. Acceptance means where an offer, where a proposal that is made, where it is made to a particular person, and that person accepts it or admits it, is said to have admitted it or is said to have accepted it. So, offer plus acceptance completes an agreement. Then the third definition which is given is, what do you mean by capacity? Capacity means the capability or competence of the person who enters into a contract or enters into an agreement with a particular party to bring about a contract is called, that term is called capacity. Then fourth term which is defined is what is called consideration. Consideration means where an act of abstinence, forbearance to do or not to do a particular thing is made to further the acceptance of a contract, it is called a consideration. Then the next term that is defined in section 2 is what is called free consent. That is, free consent means where the parties agree to enter into a contract or enter into an agreement with the same state of mind and and also have a consensus regarding the subject matter or the subject matter of the person with whom they are dealing with. That is called free consent. That is, the consent should be free. అనుమతి ఇచ్చడం లేకపోతే ఒప్పుకోవడం పూర్తి మనసిమితంతో ఉండాలి కానీ ఏ విధమైన ప్రెషర్ ఉండకూడదు. దట్ ఈస్ కాల్డ్ ఫ్రీ కన్సెంట్. The legality of object, that means where the contract agreement that is entered into is for a furtherance of a legal object and it's unlawful and it's not unlawful or illegal as declared by law. That is called legality of object. Then the next one that is defined is indemnity. Indemnity means it comes under the second part of the Contracts Act, where a loss or damage is sought to be is likely to be sustained, and that loss or the damage is agreed to be reimbursed or corrected by the opposite side. It is called a contract of indemnity. Then contract of guarantee. What do you mean by guarantee? Guarantee means where a third party tries to secure the debt by saying that he stands surety for the amounts due and payable by the principal debtor. That is called a guarantee. Then next one that is defined is the contract of bailment. Bailment is where possession of goods, please underline the word, where possession of goods is delivered by a person called the bailer to a person called the bailee for a consideration for a limited duration of time, for a consideration called the higher charges, and also subject to a super added condition that once the purpose is accomplished, the goods will have to be returned back. Then we have the next definition is pawn or pledge, where movable property, please try to follow carefully, please, where movable property is offered as security for securing a pecuniary liability, it is called a pawn. And who is called a pledgor? The person who offers the proper movable property as security is called the pledgor or the pawner, and the person to whom the property is offered as security is called the pawnee. Then the next one is what is called last chapter in the Contracts Act is law of agency. Who is an agent? Agent is a person who acts for and on behalf of the principal, brings about a contractual relationship between his principal and a third party, and acts for and on behalf of the principal in all matters, and for all practical purposes, he conducts and transacts the business for and on behalf of the principal, and he brings about a contractual relationship between a third party and his principal. And then for what all acts he does, he is said to have done in accordance with the agency agreement which is in his favor. Now the agent has been called in different names or different nomenclatures. We call them as declared dealers. We call them as stockists, and we also call them as C&F agents, so on and so forth. So this is the entire purport of the entire Indian Contracts Act. This is a very verbose enactment, please. Please bear it in mind that I've got a time constraint also because of our professional commitments, that there will be no repetition of this subject in future. And that is the reason why I expect a full participation of the candidates or the subscribers to the show. And please, I assure you that I will be going at a very, very slow pace, because the question is we have to follow it very, very carefully. Without the knowledge of the Contracts Act, your knowledge of mercantile law or the commercial law will be absolutely blank. That is the reason most of the commercial laws you will have to keep in touch. Please remember, as far as the old Contracts Act was concerned, it was a verbose enactment. It contained within itself nearly about 800 to 900 sections. Contracts Act originally contained the Sale of Goods Act, then the Partnership Act, then the Specific Relief Act, then the Railways Act, then the Carriers Act, then the Negotiable Instruments Act, so on and so forth. But what they thought was it was too verbose and very difficult for us to assimilate and to follow. And that is the reason why every enactment started getting separated from the Contracts Act. And now, today, as the Contracts Act stands, it's an emaciated form of the original Act. Now we have the Specific Relief Act of 1908 as amended in 1963. Then we have got the Sale of Goods Act of 1872, which has been amended, and we have the present Sale of Goods Act of 1932. Then we had the Partnership Act of 1872 in the Contracts Act, which has now been separated, and we have the separate enactment called the Indian Partnership Act of 1932. Then you have got the Negotiable Instruments Act, which was passed along with which is included in the Contracts Act. Now it's a separate enactment called the Indian Negotiable Instruments Act of 1932. Then we have got what is called the Specific Relief Act 1908, which is now the Specific Relief Act of 1963. And the Indian Railways Act, we have the 1950 Act, and as far as the 1925, I'm sorry, as far as the Carriers Act is concerned, we have got the 1950 Act. Like that, all this deserted the great grandmother and became a separate enactment by itself. So today, Contracts Act is a skeleton of what it was earlier. So knowledge of the commercial law, knowledge of the Contracts Act is absolutely essential to understand the mercantile world and the usages that are prevalent in the mercantile world or the commercial world. So the Contracts Act consists of Section 1 to Section 75. They are called the General Principles of Contract, and Section 120 to 150 or 152 is a contract relating to indemnity and guarantee. That's specific contracts. Then after that, we have got the law of bailment, including pledge and pawn. Then after that, we have got the law of agency. This is a scheme of the entire Indian Contract Act of 1872. Here, please remember, we will go definitions one by one. What is an agreement? An agreement is one where it is entered into between two parties, one called the offerer, where an agreement is one where it is entered into between two or more parties, where the person who makes the offer is called the offerer, and the person to whom the offer is made is called the acceptor. Are you able to understand, please? Where a person makes a proposal to do or not to do a particular thing, in order to obtain the assent of the other or the acceptance of the other, is said to be the offerer, and is said to have made an offer. Then what do you mean by acceptance? The person to whom the offer is made communicates his acceptance in toto, or is saying that he is agreeing to enter into an agreement with the offerer. He is called the acceptor. Then third one is that once the acceptance is made, that it should have the person who has made the acceptance, the person who has made the offer must be competent to enter into a contract. I'll tell you what competency means, or otherwise I'll discuss it later. Then every contract or every agreement has to be supported by consideration. Consideration means where there must be recompense for parting with certain rights. That is called consideration. Consideration means the price which you agree to pay, the price which you agree to pay to accept the offer and to fulfill the offer by acceptance, that should be supported by consideration. It must be money consideration or anything else. That is called consideration. And under law, it is also said that a contract without consideration is a nudum pactum and it's a nullity and it's not enforceable under the law. Right? Then next one is free consent. Free consent means where the acceptance that is made, where the consent is given, should be free and fair. It should not be vitiated by any of the vitiating elements of contract, which we will deal with in detail, to say that you should not be pressurized to accept the offer, then consent should be free. And for consent to be free, it is said consensus ad idem means both the parties should agree on the same identity of the person and identity of the subject matter. Then we say there is a consensus ad idem and there is free consent. And the last one is legality of object. That is the contract that is made, agreement that is made should be in pursuance of an object which is not forbidden by law. It is called legality of object. These are the various terms which are defined under Section 2 of the Indian Contracts Act. Then, first and foremost is what are the basic essentials of a valid contract? But before going to that, we will discuss a maxim called acceptance is to an offer. Please underline acceptance is to an offer what a lighted match is to a train of gunpowder. That means, you know what gunpowder is, gelatin, so on and so forth, which is used for blasting rocks and all. Suppose you have a tray of gunpowder. So long as the gunpowder is not ignited, not you don't light a matchstick in order to burn it, it remains a gunpowder. But once the matchstick is lit and there's a big explosion and nothing can be retrieved, that means once acceptance is made, once acceptance is made, it's something like an accelerator or a lighted match, which is to a train of gunpowder. When you light a match, the entire explosion takes place and nothing is retrievable. Then it is said that that is the significance of acceptance. So an accept offer plus acceptance is equal to an agreement, right? Now we understand there are various agreements which we enter into in our day-to-day life. There are two things called social agreement. Second one is legal agreement. What do you mean by social agreement? Social agreement means where either a party, be it the offerer or be it the acceptor, desire that in case of breach or violation of that social agreement, they should not they should be attended to by legal consequences, then alone the legal formalities follow. For example, suppose I invite you for a cup of tea or breakfast in my house on a particular day at a particular time. Then on that particular day, let us say I'm suffering from some illness, I'm suffering from some infection, or I'm not able to keep up my commitment. I'm not able to host a tea party for you or a snack party for you. Then, in that case, you cannot say, sir, expecting that you are going to host a tea party, expecting that you are going to give me snacks or tiffin, and I've made all arrangements. I've asked my wife not to cook at home also and not to prepare my breakfast since you have not prepared the breakfast or not prepared the tea and you have violated the terms of the contract, terms of the agreement between you and me. I have suffered damage. Please remember, they are all called what is called social agreements. Social agreements means in a society where we live, we try to maintain camaraderie, we try to maintain friendship, we try to maintain closeness, we try to maintain contact with each other, we try to invite each other for parties, for breakfast, for lunch, for dinner, or for a marriage party, or for any function in our house. But suppose, let us say, any social agreement, because of unforeseen reasons, you are not able to keep up the commitment and you violate the terms of the agreement between you and the opposite party, the opposite party cannot make you liable as far as damages are concerned because social agreements in the eye of law or no agreements at all. Whether they are followed or not followed, that's a different matter. You cannot resort to legal proceedings in a court of law. But what are the agreements which are enforceable in a court of law, sir? Only those agreements which the parties desire, please agree, follow, only those agreements which the parties agree that they should be followed by legal consequences in case of violation or breach. Only those agreements are contracts. That is where the parties desire that in case of violation or breach, they should be attended to by legal consequences. Only those agreements are contracts. That is why it is popularly said all contracts are agreements, but all agreements are not contracts. That means it says all contracts, to constitute a contract, there must be an agreement. But every agreement, a social agreement cannot be a contract because it's only a social obligation and they do not come within the mischief or ambit of the word contract. Are you able to follow, please? Then, next one is the question is what is meant by an offer? Offer is when one person signifies to another his willingness to do, abstain from doing, or forbear from doing is said to have made an offer. Where any person signifies a proposal to do, abstain, or forbear from doing a particular thing, he is said to have made an offer. Then, what do you mean by acceptance, sir? Acceptance means when that offer comes to the knowledge of a person, and that person signifies his acceptance and says, "I am bound by your offer. I am prepared to take it." Then it is said it is called acceptance, right? Then offers are of two types. One is called a specific offer and another is called a general offer. What do you mean by a specific offer? For example, offer doesn't exactly mean a contract. Here, suppose let us say certain vacancies arise in the bank, or certain vacancies arise in the in the railways, certain vacancies arises in the aviation sector, or certain vacancies arise in the corporate sector. The question is there is an offer made. Desirous people may apply. Doesn't mean that just because you apply, you should get the post. No, you should apply it in the prescribed form, in the prescribed format, and in a particular way, either by post or by courier or by sending it, mailing it to the online or to the offerer concerned. Then the terms of the offer should be strictly complied with. And suppose, let us say, then in that particular way, it is called, suppose, let us say, they make an offer only to you. Only you are supposed to be a specific person. It is called, the offer is made to a specific person. And who has to accept it, sir? That person who is specified alone should accept it. No other third person can accept it. And it does not amount to an agreement. So the question is specific offer means when it is made to a set of people or it is made to a group of persons. For example, suppose junior civil judges advertisement comes, it says the recruitment is only for scheduled caste people or scheduled tribes or backward class. A person from the general community cannot accept it and then make his application. Why? Because the offer itself is very, very specific. It is made to a specific community who belong to the scheduled caste, scheduled tribes, or backward classes, or the armed forces. Only those persons can accept the offer. You and me cannot accept it because we do not belong to that particular class or category regarding which the offer is made. Then, sir, the question is there is another thing called specific cost, that is general offer. Please remember, the offer need not be made to a specific person. It can be made to the entire public at large, and any person from the public who comes forward, accepts the offer, and performs the terms of the offer, is said to have accepted the offer. Then the question of he is definitely entitled to the fruits of the agreement which he has made. I'll discuss the case law also on that particular aspect. Then, sir, the question is next we come to capacity. Capacity, there's a separate section for that. I'll deal with that. Then we have got consideration. I've already discussed in the definition, legality of object also. So now let us come one by one. First and foremost is whether a tender is an offer or only an invitation to offer. Here, the famous case or the decided case on that aspect is a case of Harvey, Harvey, Harvey versus Facey, Facey. Harvey, Harvey versus Facey, Facie. In this particular case, what happened was Facey uh, made an ordinary invitation to the entire general public, saying that Fassi, the question is, Harvey made inquiries from Fassi whether he is intending to sell his property, and if he is going to sell, what will be the minimum price he expects, right? That is, Harvey approached Fassi and inquired from him whether he is interested to sell his property, and if so, what is the lowest price. Harvey approached Fassi, who had a property, and inquired from him whether he is willing to sell. That is the first question, whether he is willing to sell his property. And second question was whether he is willing to sell for a minimum price of 10,000 pounds. Then Fassi replied to it by saying, "I am willing to sell my property," but he did not quote the minimum price. Then the question arose whether an acceptance concludes the agreement between the parties. Please bear in, two questions are asked. One is whether you are willing to sell the property. Yes, are you able to follow, please? Second thing is quote the lowest price. First part of it is accepted to say I'm willing to sell my property. But second question that is asked, it was not answered. Whether you are willing to sell it at 10,000 pounds. Here, the question is it's only an invitation to offer. Please remember, as far as the price is concerned, it is reserved by the seller. He never quoted the minimum figure. So it doesn't mean it has been accepted by the proposed seller. The question is it's only an invitation to offer. It is not an offer in the full sense. So even assuming for a moment you have asked two questions, and just because he has answered, the other party has answered, I'm willing to sell my property, but it does not quote the minimum price, it means it has not been accepted. So an invitation to offer is not a concluded contract, and there is no agreement, and it is not enforceable in a court of law. And then let us take the second example, sir, tender. What do you mean by tender? Most of the quotations which are as far as the government is concerned, quasi governments are concerned, local authorities are concerned, gram panchayats are concerned, companies are concerned, or so on and so forth. Normally, they do not undertake certain construction works or certain works which are concerned with the organization. So for that, they call for tenders. When they call for tenders, they also prescribe the mode in which the tender has to be submitted. They say first and foremost is it should be by way of an application. You must quote your price, minimum price, and then your expertise and skill, and then what is the minimum quotation which you give as far as the contract is concerned, and then as far as the tenders are concerned, along with you, so many people apply for for tenders. Then in that case, the tenders are accepted by the tenderer, be it the government authority or the quasi-government authority, and then the tender is opened on a particular day, and then whoever is the lowest tenderer, whoever quotes the lowest figure, the tender is knocked down in favor of that person who has quoted the minimum price or who is eligible to be the successful tenderer. Just because you have submitted a tender form, so just because an offer was made, you have submitted the tender form, it does not mean that you are the acceptor and the tender should be given to you. No, a tender is only an invitation to offer. Amongst so many people, you are one of the person who has submitted the tender form, and it's subject to acceptance, subject to the tenders being opened, and then you being declared as a successful tenderer. There is no question of acceptance by the government, acceptance by the quasi government body or the local body that your offer has been accepted. No, the question is, it's only an invitation. Among so many multitude of people, you are one of the persons who has quoted it. You are one of the persons who have submitted the tender. It is only an invitation to offer, and it is an offer, not an offer at all. Are you able to understand, please? Second thing is tenders. Then, as far as acceptance is concerned, it is said when is an agreement completed? An agreement is complete, or when is an offer completed? I put it that way. An offer is completed once it is accepted by the opposite side, and the opposite side acts in consonance with the offer that is made. Then it is said an agreement takes place between both the parties. That is the offerer and the acceptor. Are you able to understand this? Then the question is, suppose a general offer is made. Suppose a general offer is made. Any person from the public or the community comes forward and fulfills the terms of the offer. Any person from the community who comes forward and fulfills the terms of the offer is said to have accepted the offer. And whatever reward is promised as far as the offer is made, that reward that particular person is entitled to claim. The leading case on that aspect is Carlyle, Carlisle, Carlisle versus Carbolic, 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 Smoke, Smoke, Ball, Ball, Smoke Ball Company Limited. Carlyle versus Carbolic Smoke Ball Company Limited. There was a general offer made in the newspaper that the Carbolic Smoke Ball Company, and at that time, England was affected with influenza, what you call it as flu. And they said they have got a product called the carbolic smoke ball, which was manufactured by the company. And if that smoke ball is used for a period of 2 weeks, as per the printed instructions of the company, and they also assured a complete cure for that particular influenza. And any person afflicted with influenza, even after using the carbolic smoke ball for a period of 2 weeks, according to the printed instructions, the company said they will offer an award of £500 to such person who is still affected with influenza. It was an offer not made to a specific person, but it was an offer made to the entire general public. Then Carlyle was a lady. Based on the advertisement, used the carbolic smoke ball for a period of 2 weeks as per the printed instructions. But still, she could not get cured of the influenza. She claimed a reward of £500 from the company. So she claimed a reward of £500 that was promised by the company as far as the breach of the obligations are concerned. Then the carbolic smoke ball company, she said that I completely relied upon the advertisement made by the company, and actually according to the printed instructions of the company, I used the carbolic smoke ball manufactured by that company for a period of 2 weeks, and still I was not cured of influenza. And since the company has made an offer of reward, I am entitled to claim the reward. She also contended that the offer was an offer in the nature of a general offer, and she also contended, saying that when an offer is of a general nature, any person from the public who comes forward and fulfills the terms of the offer according to the printed instructions is deemed to have accepted the offer and is entitled to the reward. The company contended, sir, the offer was not made to a specific individual, but it was made to the general public at large. And since Carlyle was not a specific person to whom the offer was made, she was entitled to claim the reward. But the courts in this case held that an offer which is of a general nature, which is made to the entire public, any person who comes forward from the public fulfills the terms of the offer by using that particular smoke ball for a period of 2 weeks under the printed instructions, is deemed to have accepted the offer And since an acceptance is to an offer, what a lighted match is to a train of gunpowder, and even if she has not, the offer was not specifically made to Carlyle, she is entitled to claim the reward because she has used it according to the directions of the company. And since the company has made an offer of £500 reward for the person still affected with influenza, then she was entitled for it. So, what is the crux of the case? The crux of the case is an offer need not be made to a specific person. It can be made to the entire public at large, and any person from the public who comes forward, fulfills the terms of the offer according to the directions given by the company, and still affected by that particular ailment, is deemed to have accepted the offer by using that particular product and still being affected with influenza. She is definitely entitled to the reward of £500. So, what does it follow, sir? So, an offer need not be made to a specific individual. It can be made to the entire public at large. Any person from the public who fulfills the terms of the offer and still gets affected, is he or she is entitled to claim the reward that is made in the offer. Are you able to understand this? That is the case of Carlyle versus Carbolic Carlyle versus Carbolic Smoke Ball Company's case. Then next topic which we will discuss in the same introduction is the capacity to contract. Capacity to contract is a person to be entitled or to be qualified to enter into a contract should be a person of the age of majority. That is, in other words, Section 11 says any contract with a person who is a minor, a person of unsound mind, idiot, or a person disqualified from entering into a contract is void ab initio. That means, in order to enter into a valid contract, the person with whom you enter into a contract should be competent to enter into a contract. That is, he must be of the age of majority, he must not be of unsound mind, he must not be an idiot, and he must not be a person disqualified to enter into a contract. We'll deal with each one of them separately, please. That is Section 11. First and foremost is it should be read in conjunction with Section 6. Section 6 says a person of the age of majority, a person who is not of unsound mind, a person who is not an idiot, a person who is not otherwise disqualified from entering into a contract are all people who have got competency to enter into a contract. Then Section 11 says a contract with a minor, person of unsound mind, or a lunatic, idiot, or a person disqualified by any law for the time being in force, their contracts are supposed to be void and nullity ab initio. Then first and foremost is how a minor is defined. Under the Indian Majorities Act, a minor is said to be a person who has not attained the age of 18 years or was not completed the age of 18 years. So a person who is below the age of 18 years is supposed to be a minor. Then who is a person of unsound mind? A person of unsound mind is where his mental faculties have got impaired, he is a lunatic, he has been admitted in the asylum, he is and he does not know what is good and what is bad, or he is not able to know the consequences of what he is doing or what he is not doing. He is supposed to be a person of unsound mind. Then third one is idiot. Who is an idiot? Idiot is a person in Telugu they call it as Aulapa. In Telugu they call it as Eddodu, or in Hindi they are called Aulapasha. That means a person who is not able to discriminate between what is good, what is bad, what is advantageous to him, what is disadvantageous to him. He does not know the అంటే తెలుగులో అంటారు లౌకికం తెలియనోడు వాడిని వెర్రోడు అంటారు. The question is a person who is incapable of understanding his actions. He is supposed to be an idiot. Then fourth one is who is a person disqualified. A person disqualified is when he has been an undischarged insolvent, or he has been declared as a bankrupt, or let us say he has been declared incompetent to enter into any legal transactions. Such a person is supposed to be incompetent to enter into a contract. So these are the various people who suffer from incompetency or who suffers from incapacity, it is called capacity to contract. So, in other words, as far as the Contracts Act is concerned, the offerer and the acceptor should be of the age of majority, should not be of unsound mind, should not be an idiot, or should not be a person disqualified under any law for the time being in force. Then you say capacity is satisfied. Then third basic ingredient is we have got what is called consideration. Every contract has to be supported by consideration. What do you exactly mean by consideration? It is said, I think in a loosely I'll define a recompense for the acts done. It is called a consideration. For example, I agree to sell a particular property to you for, let us say, 50 lakhs. Then I divest myself of the proprietary and titular and possessory rights in respect of that property, and those rights get vested with you, the titular, possessory, or proprietary rights. Then it is said, what is that? I part with the property. I get, and in consideration or in return, I get the money, which is the value for the property which are transferred to you. That is called consideration. Then, for example, every one of us work on some consideration or the other. For example, suppose let us say you are an advocate, then please remember you are not doing free service, you are not doing social service. What you do is you undertake to do a case for a particular client and you get compensated by the other side by getting your advocate's fees. Then, in consideration of the services, legal services rendered by you to your client, or a professional services rendered to your client, based on your skill and experience, the client compensates you by paying you the fees. And that the question is your services is in consideration, or the fees which you receive from your client, or the consideration as far as the client is concerned, he exchanges money with the services which he avails of you. So, in other words, it is supposed to be vice versa. You offer your services, he pays you for that. He takes your services and he pays you for that. That is called consideration. Consideration is of different types. We will deal with it when we come to that particular chapter in the proper perspective. Then the next one is free consent. What do you mean by free consent? Please remember, suppose you put a person under threat of bodily fear, danger to his limbs as well as the property, or you try to take his consent or forcibly by putting him under fear, then it is said the consent is not free. Unless the consent is free, unless you voluntarily agree to that, your consent, the acceptance which you made is not free and fair. Then in that case, the contract, I tell you what are the consequences of it. So consent should be free. There must be an identity as far as the person with whom you are dealing with, or there must be an identity regarding the property with which you are dealing with, and there must be meeting of minds and meeting of body, meeting of the person with whom the contract is made, and meeting as far as the subject matter is concerned. Then we say there is a consensus addendum. Unless both of you meet and agree on the same thing at the same time, then if free consent is not present, the contract is vitiated. Then we go to the last one is legality of object. Legality of object means, suppose let us say you enter into an agreement with a particular person, make an offer to the other person. I will let out my house to you, but use it as a brothel. Have a prostitutes then there. Or let us say use it for gambling, or use it for matka, or use it for storing narcotic drugs, or use it for doing an unlawful act, or trying to have a meeting to overthrow the established government of the state, then all those things are supposed to be legal or unlawful. And unless the contract which you make is for a legal object and lawful object, the question is the contract is not enforceable. For example, suppose the government is playing with a policy of what is called prohibition. Suppose, let us say, till yesterday, let us say, liquor could be easily sold. But tomorrow the government gets a law introducing total prohibition by saying that sale of liquor and consumption of liquor and the question of vending of liquor is prohibited, and liquor is a prohibited trade. Then, in that particular case, suppose there is an agreement made regarding that, the question is it is covered by legality of object. Even if a contract or an agreement is made, The question is, it's not enforceable. So this is as far as the introduction to the subject is concerned, from the point of the first, first and elementary object Act. Then, sir, like the Transfer of Property Act, which I dealt with it earlier, the question is in general, in Transfer of Property Act also you've got general transfers and specific transfers. But as far as the Contracts Act is concerned, we have got the general contracts, general principles of contract, and another is called the specific contracts. But as far as the general principles of contract is concerned, it comprises of mostly the elemental principles or the fundamental principles, which has to be kept in mind while dealing with the subject. I think this is as far as the introductory part of the Contracts Act is concerned, dealing with Section 2. And the subject in the proper perspective, from the topic wise, we will be discussing it from tomorrow onwards. Thank you.
Good evening, all. As of today, there is no introduction session with you. We will come back to you one by one. Please be patient. It's a 60 days program. Don't miss any kind of program.
No repetition.
No repetition further. But still, for your reference, we are keeping in YouTube also. Right? Keep reserve your questions with yourself. We'll come back to you on the same. Thank you. Thank you very much.